No, no, no. You go in proper sequence. Continue.
Good. All right. Good. Let me continue. So that is what transpired. So we had what we had. As I said, the interlocutory motions, all of them, the court. Then they just ruled. Then remember, we had this conspiracy to commit fraud charge filed since the 19th of May. They do us out of magic, trying to get the matter not to start. So eventually now, on the 25th of September, the trial actually started. 26th of September this year, the trial in this conspiracy to commit fraud charge actually commenced. Right? 24 witnesses were called by the prosecution. And let me show you what the charge is. Let me show you what the charge is. This is what they said the charge. This is the particulars of the charge. Between Friday the 1st of March 2019 and Tuesday the 7th of July 2020, at the Guyana Police Force Headquarters in Very Kingston, Georgetown, in the county, Georgetown, the Georgetown Maltese District in the county of Guyana, conspired together and with other persons unknown to defraud the Guyana Police Force of $10,056,000 Guyana dollars by paying Paul Slowe, Kimpton Conway, Claude Whitaker, George Fraser, Mark Gilbert the said $10,056,000 Guyana dollars without complying with the proper procedures purportedly to do a review of the standing order, which had already commenced in July 2018 and concluded in March 2019 by the Strategic Planning Unit of the Guyana Police Force. That's the particulars. That is what they have to prove during all of these days. That is what they have to prove. Now, and I send a link to him. I hope I can get Mr. Tadin here shortly. Because what happened? When the trial started, they were referring, again, let me back up to say, the matters were, or the matter was there are matters because in addition to the conspiracy to commit fraud, they also charged Washington and Sutton, who were finance officers during this period, with misconduct in public office. And these matters were tried concurrently, and all they were tried together, right? So during the course of but before I go that, I said the matters were instituted, the charges were instituted indictably. Now, an indictable charge means that if it continues to be indictable, the magistrate will hold a preliminary inquiry to determine if a prima facie case has been made out. If the magistrate so decides, then it goes to the DPP. The DPP commit for trial. She indict, and you go before judge and jury. But the Administration of Justice Act of 1978 provides for indictable charges to be disposed of summarily. So they made an application for a summary disposal, and after all the arguments, the magistrate ruled the matters were to be disposed of summarily. In other words, the magistrate will hear the case and try the case. So the case, now what you have to do then, that once you have a summary disposal, the law requires that you do what we call disclosure. So the prosecution has to provide the defense with all the statements and stuff that they intend to use during the course of trial. That is critical, that is crucial. Now, when the trial started on the 25th of September and continued, it was then realized that a lot of the things that they were referring to, like vouchers and standing orders, and those things were never served on us. So they're trying to ambush. So therefore, the defense lawyers objected, right? The lawyers objected. And once the lawyers objected, then the other argument, of course, the prosecution tried to convince the magistrate that the thing should be accepted. The magistrate ruled that with regards to the fact that the trial has already started and the prosecution had all this time to disclose. They only disclosed the documents in July of this year. They had a long time to disclose. They did not do that. She ruled that she's not going to allow additional disclosure. You know what they did? They filed a statement of claim. They sued the magistrate over that action. They sued the magistrate in her private capacity because she ruled that she was not going to allow additional disclosure at that time. They sued her. They claimed that they had applied for a stay. In other words, to prevent her from continuing. Apparently, that stay was never granted. When the matter resumed, because she had adjourned, when the matter resumed, she told the court she has not been given any order by any higher authority not to proceed, and she proceeded with the matter. She proceeded to hear evidence in the matter. At a later time, again, they then filed a fixed date application in the High Court to stop the magistrate from proceeding with the matter. Again, a short adjournment was made. Nothing, the High Court did not prevent the matter from continuing, and the matter continued. And the last set of witnesses were called on the 21st of December, and the case was closed then. The lawyers, our lawyers, made no case submissions. We're talking about lawyers. I was represented by Mr. Nigel Hughes and the associates from his office. We had Mr. Patrice Henry, we had Mr. Dexter Todd, we had Mr. Darren Wade, and a few other lawyers, but they were the prominent ones in the case. Right? Now, the matter closed. No case submissions were made. The prosecutor, in response, said he was relying on the evidence provided. The magistrate adjourned to today at 11:30 to deliver a decision. When it got to the court this morning, the magistrate read a lengthy decision. The magistrate read a lengthy decision and dismissed the charges. And I'm going to tell you, as I said, I'm waiting on Mr. Dexter Todd, Dr. Dexter Todd, to come in, and he's going to explain some of the legal stuff to you. Well, CC, summarize where we are so far so I can see if I get Mr. Todd.
I wonder if you could put back the particulars of offense. Thanks. Now, I've been I served 29 years in the police force. I've been an investigator, a prosecutor, station sergeant, sub-mission officer, commander. And I have never seen a more ridiculous particular offense than this one here. Here it's saying that we conspire. And just going back into the trial, there wasn't a scintilla of evidence, an iota of evidence to show that there was conspiracy. Nothing whatsoever, whether by words, whether by action, whether by demeanor, nothing whatsoever. The magistrate alluded to that. And it also said that we received $10,056,000 Guyana dollars. No evidence to show that any one of us received a cent. The crux of the charge that they defrauded the Guyana police force of $10,056,000. No evidence to show that any one of us, Clinton Conway, Paul Slowe, Claude Whitaker, George Fraser, Mark Gilbert, received not even, I was to use a common term, not even a Granger. And here the charge, and the charge has got to be clear. They're trying to ambush us, and they say that we fail without complying with proper procedures. What are proper procedures? The procedure should have been stated in this particular offense, and nothing was stated. What are proper procedures? No evidence left to show what are proper procedures, and then they say the standing order was already reviewed by the strategic unit. What we got to do with that? What we got to do that? This part is so bad for duplicity, that I've never come across one like this before. And as the magistrate said, we can come to that later on, that they failed all the limbs that they had. They failed to think that they have not proven their case at all. And this particular offense has got to be clear. It must talk about one thing only. It mix up. Maybe that's why they mix up the evidence, and there's no evidence whatsoever. 20-something witnesses come, and none to show that they had conspiracy, none that we received money, none that to say what were the proper procedures. And then they're talking that the standing order was already reviewed. If it was reviewed, it was reviewed. And persons say, give evidence. I think one of the witnesses, Delph, said we reviewed 58 standing orders. If even Kendall, the no superintendent, she says we reviewed standing orders. So I really understand. As I said, it wasn't about crime. It was about political. Charge Conway, charge past Slowe, and then move to have them removed from the service commission. And they went further than that. Paul, you didn't mention, but for me, they approach the the large scale mining company that I was working with, asked them to revoke my contract as a security consultant, and assure Paul they talked to Critical West Indies to influence them to not to renew your contract. So the thing was vindictive, spiteful, and you could find all the bad words to use what really happened. It wasn't about any crime. It wasn't about any conspiracy. It was about targeting Conway and targeting Parslow, and the rest are just, who mentioned, just collateral damage. Paul.
Yeah, you're correct. As I said, the motive, as I've said this afternoon, we deal with the motive behind this charge. And I'm sure, having laid out all of these things to you in sequential order, you could understand the motive was never to get a conviction, because they know they couldn't get any conviction. No crime was committed. We never did anything wrong. They're saying that we did not follow proper order. The commissioner of police, Mr. Leslie James, called us and asked us to assist with the reviewing of this standing order. And as Mr. Conway said, even if the standing order had been reviewed before, which it had not been done, what that has to do with us? The commissioner called us and he said, look, he wants us to assist in the review. I agreed. We all agreed. They provided room and all of that for us to work. During the course of this meeting, with the one meeting we had with the commissioner, nothing about payment was mentioned, nothing at all. We subsequently learned that the decision was being made by the commissioner's team that we should be paid a stipend for the days that we worked. And they are the ones, the same strategic unit, they are the ones who prepared the vouchers and so on, petty contracts and so on, for us to be paid for the days that we work. They are the ones. We did not prepare anything. And interestingly, during the on the 21st, the main investigator was this one Ramana, the same Ramana who had arrested the lawyer for advising our client to remain silent. He was the main investigator. And on the cross-examination, the lawyer, Mr. Todd, asked him, once he established he was the main investigator, do you have any voice note of these people conspiring? He said no. Do you have any email to support this allegation? No. Do you have any text messages? No. Do you have any WhatsApp messages? No. Absolutely no evidence that they're talking about conspiracy. And the magistrate today went through in detail what a conspiracy is, all the case laws she read. Because, we should say it here and now, because the prosecutor said he was instructed to appeal, to give notice of appeal, which he did. You can appeal how much you want to appeal all the way to the CCJ. Waste of time, waste of taxpayers' money, because there was never, ever any case. And they know that. But as we said, the motive wasn't for convict anyone. The motive was to make sure that Slowe and Conway are charged, so that the 19th, the charge is filed, and the very 19th, the Prime Minister writes to us to tell us that he must show cause why he should not advise the President to have us removed from the Police Service Commission. Clear. And then let me talk about it further. Because Andrews Jr. was in charge of the Strategic Planning Unit at the time when this thing started. He was charged in this conspiracy. He was charged. The officer who took over from him, Nicola Kendall, and did the exact same thing, signing the vouchers, approving payment, she was not charged. She was not charged. They said you did not follow standing procedure. The man who was to follow procedure, if you are going to talk about tender, having the thing tendered because of the amount and all that, is the man who employed us. That was the commissioner of police at the time. He is not charged, but Slowe is charged and Conway is charged. It makes the motive crystal clear. They wanted to get rid of Slowe and Conway from the Police Service Commission, because they knew that the matter that Brutus filed didn't go in no place. They knew that the Chief Justice would throw out the matter. It had no substance. And they further knew that once you threw it out, the police service commission in place would make the promotion and promote people who did not want promoted. And let me tell you this further, because when they made the promotion on the 2nd of July last year, 45 persons who were promoted by us on the 28th of June 2021 were affected. 35, I think it were affected. And many of those persons still have not been promoted. Some people retire and all of that. Still have not been promoted. And I have said to them the fact that the court ruled, I don't know what they're waiting for, on the 24th of March, the judge said, Justice Gino Prasad, that the action by the president was unlawful. And the most important part, he said, the thing was has no legal effect. In other words, the Police Service Commission was never suspended. So all the actions and all the promotions made by the Police Service Commission I chair are valid. But it is up to the people who are affected to fight the case. It is up to them. So the motive has been laid clear. They wanted to get at Slowe in the first place. Because remember, it's me and I'm the man who met with the president. I'm the man who said to the president that no, this thing can't. People who would pending this many matters cannot be promoted. That's what the procedure is. I am the person who met with him. I'm the person who told him so. I am the person who spoke to him on the 23rd of December. Conway is also collateral damage. He is a member of the commission. It's me that wanted to get that because I had the interaction. And people like Whitaker and all of those people are for the collateral damage, right? But they didn't extend it to the commissioner if you're saying proper orders wasn't followed. You didn't extend it to Kendall, who did the same thing that Andres Jr. did. Same thing. Signed vouchers, and she gave that in her evidence. And the magistrate made that clear today. Hear what some of the things that the magistrate said. I'm still waiting on Mr. Todd to join me. I know you got a notification, but he did indicate that he would have been in court a little late. So he promised to join around 5. So anytime now. The magistrate in handing down a ruling, she said, in handing down the decision, the magistrate ruled that the evidence of the prosecution witness clearly contradicted the prosecution's own case as to whether an agreement existed between the 5 defendants and the Guyana Police Force in relation to the revision of the Guyana Police Force standing order. So they wanted to claim that we didn't do no revision. And their own witnesses said that they were part of the revision process with us. And then the magistrate went on to say, based on the evidence provided, it was clear that the review of the standing orders of the police force was done by the retired officers, and the commissioner of police at the time was aware of the work being done by the men. She said there was no evidence that the agreement was not authorized or approved, and services were rendered to the police force. Now the magistrate, a long ruling today, went on to say, and this is the lawyers saying this. They said, we were sure, that's what one of the lawyers said, Mr. Todd, we were sure that this matter would have stopped at this stage because the charges were bad. And when at this stage, what he means, at the no case submission stage. So in other words, what we're saying again, we're saying, and SOCU is the thing, none of SOCU cases going beyond the no case submission. Once they present the case to the court, and the defense lawyers point out the defects in the case, it ends right there, no case submission. No case submission. So Mr. Todd said today that we had no doubt that this matter could not get past a no case submission, none whatsoever. And then he said the statement disclosed in court raised many questions, including whether or not files were indeed sent to the office of the Director of Public Prosecutions before charges were laid. Mr. Todd raised a question, and he's on, I'm going to get it on just now, as to whether this file was sent to the Director of Public Prosecutions to review before charges was laid. I know, yes, they were. And I know that the Director of Public Prosecution